taking so long to get started. I'd like to welcome everybody here today. This is the Land Use Committee. First, we'll call the meeting to order. And right now, we have Sharon Williams on the telephone. I'd like to have a motion and a second letter. Sharon Eden, all in favor, say aye. Aye. Opposed, same side. Okay. Motion passed. Welcome, Sharon. Okay, first on the agenda is approval of the January 3rd, 2023 minutes. Can I have a motion to Linda? Matt? Can I get a second out of you? Thank you. All right. All in favor say aye. Oh, hold it. Is there any additions or corrections to the minutes? Okay, hearing none, let's vote. All in favor say aye. Aye. Opposed, same sign.
Aye.
Okay, moving on. We'll have the reports. Tri-County Regional Planning Commission minutes are in your packet. Are there any questions? Okay, we'll put them down to be, what's the word that they use for this? Received and filed, thank you. Next, we have unsafe structures, and Andrew, will you take care of that for us?
Yes, thank you, Mr. Chairman. This is the monthly unsafe principal structures and structures unfit for human occupancy list. This list has added a couple since last month. It's constantly evolving and is being updated based on the status with the hearing officer and compliance. The first page that you see are properties that will be included in future grants as demolition funding becomes available. We anticipate that there may be an application coming up in the next couple of months through the Illinois Department of, I've drawn a blank here, I'm sorry about that. Illinois Department of Human Services, thank you. So that's all I have for that particular report this month, unless there's specific questions.
Any questions for Andrew on the unsafe structures? Okay, moving on, we've got the development, I'm sorry, I gotta get back. Development summary. Can you do that for us?
Absolutely. This report is included each month and is non-residential building, new constructions, additions, alterations, as well as new residential construction. It varies from month to month. It also has a snapshot of all of the permits that the department has issued, as well as the cost of construction as provided for by the builder or applicant.
Any questions for Andrew on this one? Okay. Moving on, we have the zoning case. It's CBA-2023-004, petition of Doug Huff. I need a motion to put that on the floor. Eden, second. Jimmy, thank you. Scott, do we usually do public comments before or afterwards?
Usually we have staff run through the case history.
Okay. Andrew, will you do that? Thank you.
Thank you. There was a lot of interest in this case, so I'm going to give a little bit more detailed overview of the Zoning Board of Appeals and how that occurred. This is ZBA 2023-004, the petition of Doug Huff. This is a special use request to allow for overnight accommodations in the A2 Agriculture District, provided that they meet the requirements set forth in Section 7.8, overnight accommodations, and per ordinance that no more than 5 rooms or suites of rooms are rented, and rooms are not rented for a period of more than 14 days. The petitioner proposes to offer an entire single-family dwelling for rent on a short-term basis through vacation rental websites. The 75-acre subject parcel consists of a 4-bedroom, 3,007 square foot single-family dwelling with an attached garage, an outbuilding, a private lake, approximately 4 acres of ag field, and roughly 67 acres of timber. The subject dwelling is completely screened from neighboring properties by the parcel's timber, and the dwelling is approximately 1,260 feet from the nearest dwelling. The parcel is located at 16829 North Staub Road in Halleck Township. There are 0 consents and 35 objections on file. 8 of the objectors spoke at the Zoning Board of Appeals hearing. The primary objections were concerns of safety, trespassing, ATV use, hunting, and other various issues. All adjacent parcels are zoned A2 agriculture. The petitioner's request is consistent with the single-family residential uses and natural features of the surrounding area. Other permitted residential uses at this location would include major home occupations. Major home occupations allow for stock and trade to be displayed or maintained on the premises and the use of tractor trailers, semi-trucks, and heavy equipment such as construction equipment as part of that home occupation. This potentially more intensive use could operate from the property without a zoning case. The property is currently equipped with security systems and cameras. Planned check-in time is 3 p.m. with a planned checkout time of 10 a.m. Development standards for all overnight accommodations are outlined in section 20-7.8 of the UDO. The overnight accommodations definition of the ordinance includes bed and breakfast, hotels, motels, as well as any type of commercial establishment where rooms are rented at a daily rate to the general public. This would include short-term rentals. The ordinance does require that the operator keep a log identifying the name, address, and phone number of all guests, and that overnight accommodations not begin until a certificate of occupancy has been issued by the zoning administrator. The ordinance also requires that no more than 4 automobiles may be parked accessory to a single-family dwelling for a period of more than 72 continuous hours. The Institute of Transportation Engineers Trip Generation Report cites an average of 2.65 trips per resident on a weekday for a single-family dwelling. The maximum number of 8 property guests would generate approximately 21.2 trips if each guest arrived in their own vehicle. The potential traffic generated by the proposed use is less than the allowed 30 automobile trips per day traffic generation for a major home occupation, which again would be a permitted use in the A2 district. No comments have been received from the Halleck Township Road Commissioner. This property is served by a private well and septic system. The Peoria City County Health Department had no objection. The department recommends that the property owner leave information on their water and wastewater systems for guests so that their systems are properly cared for and maintained. The department also recommends that the property owner have guests notify them of any problems with these systems during their stay. The petitioner's request is consistent with the goals of the county's comprehensive land use plan, environmental corridor designation, as the property's natural features promote visitor attraction through recreational and ecotourism opportunities. The petitioner states that the property would be used as a retreat for families to enjoy nature, including fishing and swimming at the private lake, nature trails through the property's timber, and a deck for bird watching. The petitioner's request is also consistent with the Peoria County growth strategy of generating economic opportunity and stability. The operation of overnight accommodations would provide income for a local business, and visitors to the area would have an additional option for lodging. Staff recommended approval with 6 restrictions. The Zoning Board of Appeals met and recommended approval by a vote of 4-1, with the restrictions listed in the staff report, also adding 2 additional restrictions to address the concerns of the objectors regarding prohibiting hunting and use of ATVs on the property by the short-term rental guests. Those restrictions do not apply to the owner of the property and his own personal guests. I'll read those 8 restrictions. The special use is null and void in the event that the subject parcel is no longer owned by Doug Huff or any entity solely controlled by Doug Huff. No more than 8 overnight guests may be present at the subject parcel at any one time. The operator shall keep a log identifying the name, address, and telephone number of all guests. This log must be provided to the zoning administrator upon request. The operator shall notify all adjacent property owners that overnight accommodations will be offered at the subject property by sending a letter through certified mail. This letter shall include the contact information of the operator. The operator must provide the zoning administrator with a copy of letters sent and a verification receipt showing that each letter was delivered or that a delivery attempt was made. Overnight accommodations may not be offered at the subject property until a certificate of occupancy has been issued by the Department of Planning and Zoning per section 20-7.8 overnight accommodations of the Peoria County Unified Development Ordinance. Overnight guests cannot hunt or use firearms. The property owner and his personal guests are not subject to this requirement. Overnight guests cannot use ATVs, recreational vehicles, and similar such vehicles. The property owner and his personal guests are not subject to this requirement. The special use permit may be terminated by the zoning administrator upon violation of the above restrictions per section 20-3.5.9 of the Peoria County Unified Development Ordinance.
Thank you, Andrew. Pardon? Sure. Jenny?
Just two housekeeping matters for, I know that some of the committee members are new to land use. The Zoning Board of Appeals is the finder of fact in these cases. So the testimony was received at the ZBA hearing, and then you all are a reviewing body that you look at the facts already found by the ZBA and decide if the facts support their ultimate conclusion of approval. Similarly, when it goes up to the county board, that's what will happen. The entire county board will take this up using the facts found at the ZBA level to decide and determine if approval was warranted based on the facts that the ZBA found. In that same vein, you all do not get to receive new testimony. Only the ZBA gets to receive testimony and evidence. So anyone who speaks today, that is simply public comment. And in your brain, you will have to, like a judge would have to, if they heard evidence that they can't consider. In your brain, you'll have to keep separate the findings of fact that the ZBA found that are available to you through the deliberation minutes. You have to keep that on one side, and you'll have to keep the public comment that might go outside of that segregated. And Mr. Ruland is also abstaining from the discussion because he was a participant in the underlying case at the ZBA level. So just wanted to make that record.
Okay, before we open up the public comment, I'd like to see if any of my colleagues have any questions for Andrew. Linda?
I am interested in adding an additional restriction, and that restriction would be to establish a requirement that every 2 years there be a life safety inspection by county zoning paid by the applicant, and the inspection would address issues such as smoke and carbon monoxide detectors, decks and handrails, egress, etc. I move, yes.
I'll second.
Thank you, Sharon. We already got that. Andrew, can you bring us up to what the county requires, what the county doesn't, what you're doing and other things, how this would work? Because we're wanting to do another thing that would involve the zoning board.
Sure. So currently, the Department of Planning and Zoning is responsible for the issuance of building permits and subsequent certificate of occupancy status, which was noted as a restriction here. Certainly, through those building inspections, we are conducting life safety inspections. So I don't think that this is anything out of the realm of the capabilities of our trained building staff. It would ultimately be up to the Mr. Huff to allow us entry into the property, certainly through the restriction. If he weren't following that, restriction number 8, the proposal was that his special use could be null and void. So I'd imagine that, you know, if Mr. Huff is willing to take on that additional restriction, that it's something that the department can accommodate. There are various permits or processes through the Department of Planning and Zoning that we're doing annual or more frequent than that, even inspections. Currently, the overnight accommodations is not one of them. That's just to say it hasn't come up previously. There are various special use cases that have similar type, at least property site inspections. There are home occupations that are having annual renewals. There are non-conforming uses that are having annual on-site inspections. So what we would ultimately do is have some sort of timeline established. You know, perhaps this is January here today. The case will go to the board in February, so maybe in the February month, every 2 years, or as the board sees fit, we can ensure that that is occurring. Ultimately, I believe it would be the responsibility of the property owner to contact us to schedule that, but certainly if that's not being done, we can be proactive as well. So we're happy to accommodate the board in that restriction as best as we can.
Thank you.
Jenny, what would this entail for us to make this an ordinance to go along with what we're doing? If you could explain that to the committee here.
There's a separate process for amending your ordinances to include this as a restriction on all or short-term overnight accommodations. So the staff in the Planning and Zoning Office would work on some proposed amendments to the ordinance and bring that to this same committee and then to the board to make that a requirement on these short-term rentals going forward. I was going to just add with the life safety inspection, I don't believe that's a defined term in our code. And Andrew indicated that the certificate of occupancy, that might look similar. So I would just like some clarification on the restriction of if it's going to be worded as a life safety inspection, that we're clear about what kind of inspection that really is going to be. So I don't know if Andrew maybe has language to propose for the restriction that would clarify that.
At this time, I don't. Unfortunately, I think it's something we can work with our inspections coordinator and perhaps even invoke some of our contacts at the ICC. The ICC is where we've adopted the building codes from. So perhaps life safety inspections can be more clearly defined through that realm. However, if there are specific items, I heard smoke detectors, carbon dioxide detectors, decks, handrails, points of egress, some of those specific, we can ensure to include them. But unfortunately, I'm not here today to be able to provide that exact list to you or to the committee.
Linda?
Would it help if the motion were amended to say that the occupancy inspection would be done and take out the word life safety? Does that help or confuse more?
I think that the department can have a list of life safety for the board at the next meeting, if that is appropriate at this time. I'm not sure I can commit to specific items here today.
Okay, that's
but
fine. I was just
in
trying to.
anticipation.
Yes, I just wanted to make this clear.
Matt?
So are all these things necessary at the first time they go through? I guess is my first question. Is there one inspection the first time? And then also, like, I almost feel like maybe some of these then makes us more responsible if we have an inspection annually or yearly, or, I mean, your house isn't inspected every year.
Right, and I think, you know, in a real estate transaction, generally you're having a home inspector come through. And these, to me, are items that, through my personal experiences, are being looked at by those home inspectors. I understand Mr. Huff is in the process of purchasing the property, so perhaps that report would be available at that level at that time. In terms of the certificate of occupancy that we are currently issuing, we're only issuing that upon the satisfaction of those restrictions. So once that log is the template's put in place, and once that certified mailing and the documentation is submitted to our department, at such time we're then issuing that certificate of occupancy to the operator, or we have in the case of the previously approved.
So is there a walkthrough inspection then first or not?
There has been, but it has not occurred every individual approval.
I guess that's my question though. Like, would an annual one actually give us more liability because we failed to do it or not? If we would have that in there. if you're liable to do it, then it's saying that we're having to check up on it. You're not checking up every year to make sure everybody's got the outlets in their house hooked up right. So you're on, you know what I mean?
I would want time to, research that specifically. I haven't looked at that specific issue, but my understanding is that inspections done by the county, we have indemnity. That those are for our purposes of issuing things like permits or certificate of occupancy, but it can't be relied upon by owners. Again, I would have to do some research there, but I believe that a homeowner couldn't then use that against the county. Rely upon that.
Jimmy?
Scott or Jenny, would this even need to be put in it as a restriction until, say we go back and look at this falls under bed and breakfasts, and if we would change that ordinance to make those comply, wouldn't all of the ones that we currently have to follow in that? Because we would be treating them as a bed and breakfast. They would have to be. This was the conversation of us having to register these so that we know about it. But if we would actually truly change the ordinance where all bed and breakfasts would have to go through this inspection process, I think that would make all of them have to go underneath it. I'm just saying, before we try to do this maybe one on the fly, if we go revisit the ordinance and then they would all have to comply with it, is that?
Anytime the ordinance is amended, you're only subject to the
Grandfathered.
restrictions at such point moving forward. So when we adopt a new building code, when we change the ordinance language, those uses that were approved yesterday don't have to follow suit. Certainly we could reach out to those individuals and see if that's something they'd agree upon, but I don't believe there'd be any requirement that they'd have to follow that. They'd be non-conforming at that point.
Andrew, could we do you have a lot of the buyers get a home inspector come in to check it out for that. Could we, instead of the county doing it, could we have that put in so we don't have that they just have to have a licensed home inspector come in and do it, and they turn in the paperwork yearly, every 2 years or something like that? Would that be easier for the county? And would that, instead of putting more burden onto you, there's already people out there that doing that the each individual and then have it as our ordinance that would be it, that would have it whether yearly or every 2 years, they have that inspection turned in and they'd have to do it by a certain time, so that way we wouldn't have to, it'd be up to the Airbnb owner to do that and keep us off of our we wouldn't have that for our schedule. It'd be put the liability onto them.
I certainly think that suggestion would address Mr. Windish's concerns. I'll let him respond to that. If it were a third-party home inspector as opposed to county staff, I'm not trying to negotiate for anyone. I think that's the question Paul's asking.
Linda, we're kind of,
Well, I think don't local fire protection districts have inspection services available because they're trained by the Office of the State Fire Marshal? And so maybe not all of them, but I think a number of them do.
I would think we'd want something that, I don't want to put a burden on another one of our, like the fire departments up in that area, I believe, are probably volunteer. I'm not positive, but I know like Limestone, we have a few paid ones, but I don't want to put the burden on the taxpayer that they have to do it for somebody else. This would be, if we could have the inspector, we can do it either way. We can either do it through our office or have an independent come in. Since we're kind of bringing this up and brainstorming it, I want to throw it up in the air and see what sticks and what doesn't, what you guys all think, which way you'd like to go. Matt?
I don't know. The more I think about it, the more I think I think it's kind of pointless. I think that passes the responsibility down, and I don't think Andrew needs anything more to do. And I think we're opening a whole can of worms that we possibly, I think a first inspection, and it's on them.
Well, I would say the reason I disagree with that is because I think, and I really like Airbnbs a lot, but I think when people go to a hotel or they go to a motel, they have confidence when they're staying there that those facilities have been inspected. And so I don't think every 2 years is an onerous requirement, but it does tell you, for example, that hopefully if there's a deck, it isn't going to collapse because nobody's looked at it.
Andrew, what would the cost be for somebody to have a home inspector come in on the average, or a ballpark figure, if we were to make it so it'd be an independent person would come in and do the inspection, and then the owner would turn that in to us? Do you have any idea what those inspections cost?
I don't have a good estimate for you at this time. I think we'd have to consider the length of time and the detail of the report. It's certainly something that we can come back with a figure. It's not an inspection per se that is already existing in the Peoria County fee schedule that's been adopted. Our fee schedule addresses specific permits. It doesn't necessarily comment on a one-time inspection. We have various hourly rates established in intergovernmental agreements for services, but I'm not in a position today to tell you how this would correspond to one of those.
Jenny, would this be something that we should have another meeting on before the county board meeting? Because we're kind of blindsiding Andrew here with all this stuff, and that way we'd have time amongst ourselves to talk, and he could give us more. Is that something that you guys would like to have, like a meeting before the next board meeting, that same night beforehand, so Andrew could get us more information?
I was going to say, I'm hearing kind of 3 different routes that it could be: every 2 years, a certificate of occupancy inspection by planning and zoning. It could be we require the property owner to supply a home inspection report that they've procured on their own by a neutral third party out in the community, or there would be something maybe more specific, like a life safety inspection that would be done, and that we don't have maybe a firm grasp on what that would entail. So I think that depending on what the committee, which way they're leaning towards, which requirement they would want or not want, you could potentially decide that today. And but if you're wanting to develop a life safety inspection checklist, then probably you would want to do a subsequent meeting.
Linda, since you made the motion, how would you like?
I'm fine if you want to wait and get the answers to this before it's finalized. So in other words, before the board meeting in 10 days.
Okay, do you have a preference or should we have Andrew look at all 3 different options?
Yes.
Okay. Matt, since you seconded, is that okay with you? Whether you want to vote for it or not, I mean.
I guess on that, whatever, but does that affect what's going on with, I don't want to change the outcome of what we decide on the rest of the case.
Jenny, how would that affect us voting today?
You'll continue today, and then when it comes time to vote, you'll first vote on the amendment. Right now, there's an amendment on the floor to add a restriction, and whether or not that gets voted up or down, then you will either vote to approve with the additional restriction or without, depending on that vote. So you'll still continue today with your votes. It'll just be if it if that extra restriction is added. If someone wants to make another motion to continue until a different date, that would be a superseding motion that we'd take up. Clear as mud? No? Yes? You guys decide what you want to do, and we'll get it we'll get it right.
Get the parliamentary procedure
Yeah.
right.
I guess with that being said, I think this needs to be a discussion at some point, but we need to let it be for today.
Okay.
Even though I seconded it.
So you think we should either vote it up or down today, whether we're gonna do that, and then figure out which way we wanna do it at another meeting after Andrew does his research?
As clear as it is to me now, I'm gonna vote no today, but I wouldn't necessarily say that with the proper discussion later.
So
Does
you
that
would,
make it any clearer?
you would prefer to have the discussion before we voted?
I don't think we should throw this in last minute right now on this case, I guess. I would rather proceed with this to be to the future is my opinion. Not that this doesn't need to be visited. So I'm gonna vote no on the restriction today. How's that?
Okay. Jenny can, and I don't know, Mr. Huff, I think, is in here, correct? Can we let him, talk with him that if he would be entertain that? It's kind of putting him on the spot, but he would have to be the one that would want to know about it.
No, you guys get to decide what restrictions,
Okay.
whether or not he likes them.
Okay, got it.
You get to put the restrictions on.
Is there any more discussion? Jimmy, do you have any questions? Any thoughts?
Is the motion still out there for this restriction, or have you rescinded that motion?
I did not rescind anything.
So my thoughts are, I'm not opposed to this restriction by any means, but I would also like to see a little clearer defined of what ZBA has to say about it, or the state's attorney. So I'm not in opposition to the thing. We've talked about it in the past, and I don't think some of the petitioners have opposition to it. But I don't really know what I'm voting on at the moment, so I would probably lean for a no today, yes for the case, and then if there was an amendment at the February meeting where it's more clearly defined, I could be in agreement for that. I just don't, it's hard to tell what, we have so many different proposals or talk that I think that this is something that probably needs to be talked about a little bit more, clearly defined, and then added in the February meeting for an up-down.
I'm fine. The only reason I would want to go forward is I do think we need more discussion. But as our attorney pointed out, if you don't have this restriction now, and I do want to do this going forward with all of these Airbnbs, this one can't be added if it hasn't been established.
Well, you could still, once the definition, you'd still go back and revisit your ordinance and have that going forward clearly, and then that's not a restriction going forward. But then what the question is here today could be a little bit more defined maybe, or answered for us to add as a restriction.
Is that
You want me to weigh in?
yes, please.
I think what Chairman Dillon is saying that you can amend your ordinance, and that would be going forward for other cases. For this case itself, I think what I'm hearing is that at this committee level, we'll vote on that additional restriction, and if it gets voted down because we're unclear about what that restriction, as stated, really means, if that gets voted down, at the all-board meeting, someone could make a motion to amend and add the restriction that maybe is clearer, and then perhaps the whole board would add that restriction at that time. Or you could have a special land use committee meeting prior to your board meeting and hash it out at this level before taking it up to the board probably would be more desirable for this group, this, working group.
So would we, if we wanted to have a special meeting, how would we do it today? We would,
I'm not trying to guess what's in your brains, but if
I
the
think
restriction, additional restriction, if that gets voted down, we're just back to our normal, the 8 that came up through ZBA, and you would continue and have you would continue on your vote to pass it up to the county board as the ZBA brought it to you with just the 8. And then if you have a special land use committee meeting, perhaps a 9th would be added once you were clearer on what you wanted that 9th one to look like.
And that could be done at the board meeting versus having a special committee
Correct.
meeting before.
Correct. That would just be the preference of the chair and the committee members if they wanted to have a
Okay.
special meeting.
Matt?
Is there any reason on this one, I guess we haven't even heard the case, but is there any reason on this one that we need to worry about sliding that? I mean, is there a reason to make this one priority rather than discuss it through the next committees? I mean, we've already got several already through. If we just run the normal process, then also everybody's involved in the conversation.
I think partially on this one, since we've had 35 objectors, we're trying to make sure that of course, this is my first one for going through, so, but other than that, I was voting as a complete count, or, as a regular county board member. I think we're trying to make sure we do this one right, because there's more than just 1 or 2 objectors. We have quite a few that we appease everybody involved, the property owner plus the neighbors, and make sure that we're doing our due diligence. And I think part of it is we wanted to make sure that we're not letting too many of them slide under and be grandfathered in, because we have 7 or 8 already before this one that we've done.
The county has approved 8.
8, okay, so this is our 9th one, and it's just, that's kind of where I feel, from what I've talked to a few of you around, that we want to make sure that we get it right and not put undue burden on anybody, but make sure that we're covering all of our bases. So, Linda, go ahead.
I'm fine. I would even be willing to rescind my motion as long as we're going to take this up with the additional information before the county board meeting.
Okay, does everybody in agreement with that? Okay, that sounds good.
All right.
Do we have any other questions, any other comments, any other things that, any other restrictions that we were thinking of? Terry?
Just a point of order, Mr. Chairman. A lot of the folks here are part of that 35 oppositions. I didn't know if some of them had the intention to speak today. If that's the case, can we allow that before
We vote.
we vote?
Scott, that's always.
That's possible,
Yeah,
yes.
that's possible. We can do that.
And what I think Jenny said at the beginning, and I'm sure she'll restate that, any member of the public that addresses the committee, 1, needs to have testified at ZBA, and 2, can only restate what their testimony was. They cannot offer new testimony. Wait, I just did that for her.
So basically, they had to have spoken at the ZBA meeting, correct?
That is correct.
And they can only restate what they spoke at that meeting.
That is correct, because this committee is not the public hearing fact-finding body, the ZBA is. So you can only consider what's already in the record. You can't allow new record to be created.
Okay. And I feel, I'm gonna ask, you guys would all like to hear their speaking before we vote on, instead of afterwards, correct? Okay. Yes, you withdrew your motion, correct, Linda?
Yes, I
Okay.
did.
Okay, so I'm gonna open it to public comment. So only those of you that spoke at the ZBA hearing are ones that can speak. And you, as we've said 3 or 4 times now, just to make sure that we get it right and that I get it right, you can only testify what you testified at the ZBA meeting. You can't add any new facts or opinions or anything. You just gotta say what you said at that one. So who would like to be first on that one? I would like you to come up here and state your name, and we'll give you a microphone. Or you can sit right there at that table there with the microphone. Would like you to state your name and address, and then proceed.
Thank you, Mr. Chairman. Members of the committee. Can everybody hear me okay? My name is Bruce Tiemann, Thiemann. I am an adjoining property owner, and while my profession is as an attorney, I do not represent the folks here. They have not hired me, and I'm not here in a representative capacity. I agree with all of them, and I think they agree with me. So in that sense, I may say things that you'll also hear from them. But I'm not here as an attorney for anybody. I'm just here as an adjoining property owner. My property, 20 acres of it, is immediately west of the subject property. We share a common boundary. I've got another 8 or 9 acres that is immediately southwest and is adjoined with a catty corner with the subject property. You have conclusions that have been provided by the Zoning Board of Appeals, but you're not required to accept those conclusions. You're not required to grant the request because the Zoning Board of Appeals has recommended it. The county ordinance clearly provides that the county also may attach new conditions. The county board. So when I say the county, I mean the county board. The county board, you're all board members and you're acting as a committee of the county board. You can attach new conditions beyond the conditions that are there, and that's under 3.5.5 of your ordinance. You can reject the recommendations and reject this special use request based on solid legal ground. The Zoning Board of Appeals got it wrong, and this is the point where it can be corrected. It doesn't need to go to the next level to the full county board. You're acting for the county board, and you are, in essence, the county board. So we're asking that you turn this around, tell the Zoning Board of Appeals they got it wrong, and reject this application. The application itself was deficient in 2 major respects and should not have been processed by the zoning administrator. Your ordinance on special use applications is very detailed, and it has minimum requirements which have to be met. 2 of those have not been met in this case, so the application itself is deficient. There's no explanation of the need for the special use petitioned at this site. There's never been a discussion of why there has to be an Airbnb at this site. That is a minimum requirement, has not been addressed. The other minimum requirement is that the application has to state and provide details of why the proposed use satisfies the review standards. So your ordinance says that the Zoning Board of Appeals and the county board have to find that this use meets approval standards. That's 3.5.4. The number 2 approval standard, the most important one, is that the special use is consistent with the community character of the immediate vicinity. And if it's not consistent, then the applicant, Mr. Huff, has to put in the application factors that justify the inconsistency. My argument is that a motel is inconsistent with single-family residences. A hotel is inconsistent with landsteads and farmsteads. So you've got a residential neighborhood, and for some reason, the zoning office and the ZBA has told you that a hotel and a motel is consistent with single-family residential. You know, it's a square peg trying to be pushed into a round hole. It's not consistent. And because it's not consistent, it should be rejected. There's no statement of why it's consistent, no statement to justify the inconsistency. It was glossed over at the last hearing, and there was a statement in the notes you were provided that the use of the property is similar to that of a single-family dwelling. Well, it's not. Single-family dwellings are not run like motels and hotels. They're not a business. And that's very important here. And it's a distinction with a difference, because if it's a single family, that family knows where the boundaries are. That family is likely to respect those boundaries. But if it's a motel or a hotel, the occupants, the guests, the customers, whatever you want to call them, are never going to know where the boundaries are. There's going to be 8 new ones every 15 days, or there could be. They're never going to know. They're going to go out and wander around, and they're going to trespass on my property and all of our adjoining property owners. And they're likely to do some things that maybe we won't want them to do on our property. We don't want them wandering around getting lost. We don't want them picking our mushrooms, our ginseng. We don't want them out there taking pictures or hunting, even though the restrictions, and we appreciate those restrictions, are against hunting and against firearms. How can they be enforced? How can they be enforced? This is a 75-acre parcel, and it's connected with other parcels that have hundreds of acres around it. These guests want to disregard the conditions. They're going to disregard them. So the enforcement has to be something that the adjoining owners can be aware of, that the adjoining owners can bring to the attention of the zoning department and the zoning administrator. And that would be trespassing. That's where we see guests and occupants on our property. And we approach them and try to take their picture and get their information, and they're probably not going to be happy about that. And then we try to relay that information to Andrew and his staff, and we try to say, please enforce this. Well, there has to be real teeth in that, because it's likely that Mr. Huff's not going to be there. He's going to hear about it secondhand or third hand. He's going to say, oh, well, we told him not to do that, or we're sorry that they did that. And we're going to say, well, go ahead and pull the special use then. And he'll say, no, give me another chance. So we want this to be a 3-strike, you're out rule. If the conditions, and we like the, yeah, thank you. I got that from Jenny last time, by the way, so I appreciate the doubling up here on me. We want the enforcement mechanisms to be very clear to Mr. Huff, that if these conditions are violated through no fault of his own, and the extra condition we're asking for is no trespassing on the adjoining properties. Very clear, no trespassing on the adjoining properties. We like this other condition too, that was brought up about the life safety
The
codes.
5 minutes is up.
Yeah. We want the special use to be pulled when those are violated. Thank you for the opportunity to come
Thank you.
back. I said all these things before too. This is nothing new.
Thank you. Who else would like to speak? I guess I should have told you up in the front that you'd have 5 minutes. From now on, I'll give you a 30-second warning before your 5 minutes are up. So else we might be here till bedtime. So with,
You can use this symbol too.
okay. Who else would like to speak? Okay. Please state your name and your address at the beginning.
Hi, my name is Teresa. I'm speaking on behalf of my mother, Lydia Iruli. My address, you want mine or you want hers? My 9930 Guinevere Drive, Mapleton, Illinois. Okay, so anyhow, Last meeting that we came in, they talked about restrictions, which I get them. I totally for restrictions. But the problem is, though, one of them is how on God's green earth can we enforce these restrictions? How can we enforce somebody not going onto our property? How can you enforce somebody not shooting or picking his mushrooms? It can't be done. And if there's a way to do it, please, please let me know. Because I was out there this past week and somebody took a dishwasher, threw it in the middle of my mother's property. Seriously? How'd you get it out there? It makes no sense. Another thing, as I talked about last time, was we are in a drought. There's a water problem. So let's say they have their little group, they have their bonfire going on. Somebody doesn't put the ember out. That's farmland out there. That's all timbers. That fast, we turn into Montana, Wyoming, up in flames. There's no fire department out there per se. I mean, they're volunteers, and I don't see how you would get rid of their people's livelihoods, their property, homes, families, the danger. It's ridiculous. People are disrespectful out there. Like I said, they threw a dishwasher out there. Somebody cut a bolt through a chain that leads up to her driveway just because they wanted to get on the property to go hunting this past week. Also, the developer made a comment about there's no place to see the wildlife and blah, blah, blah. Well, there is. Wildlife Prairie Park. They have cabins, beautiful cabins, nestled in the woods. You can sit on your patio and watch the buffalo come up to the pond. Miles of trails. You've got hiking and biking, canoeing, everything you want. Not a lot of people there. The only difference is they do not allow hunting or ATVing, and it's enforced. There's no way to enforce this there. And the septic system there is not big enough to hold 16 people. I live in a house that has a septic system. No way the water can handle that because it's going to drain into the pond, and then you got a whole issue of germs and bad stuff. So, I hope I kept my 5 minutes. Any questions? Huh? Oh, I do. Oh, well, I'll give it to the next person. Read it over. Thank you for listening to me rant and rave, but I'm just trying to look out and trying to help the people that live out there. I just think it could be a problem. So,
Thank you.
Thank you.
Would like to speak next?
My name is Jeff Dunbar. I live at 222 East Halleck Hollow Road. You might notice that that's not necessarily adjacent to this property, but if you jump a half a property over, you get onto a Peoria Park District property. That's a preserve, and I'm on the other side of that preserve. This gentleman's wishing to put in some kind of short-term rental facility that he'll rent out to people that he doesn't even know. They're going to come in and spend a week or two and do whatever they want because nobody's there to keep an eye on them. That's my understanding of this thing. And it's pretty easy for these people to get lost and get wandering and end up hard telling where. It's already apparent that there's a problem out there, and we don't need it to continue and be even worse. So I would hope that you all have the sense to not let temporary housing where the person doesn't live on the property rent it out. Any questions?
My name is Marcus Horan, and I live at 612 South Stillwater Drive in Chillicothe. My father passed away the day we got the hearing. I will likely be a resident at a property just north. Our farm ground is adjacent, which is across the road from this property. My big concern with this property is preservation. Living out on the farm I was born and raised there. I go out to the farm every day. Likely move out there after things settle. This is something we've continued to deal with over the years. Whoever's lived there, it's been a problem. 75 acres, it's fantasy land back there, but it's the keys to the country. They go outside of everywhere they're not supposed to be. They come out in the road, they go out on our property, they're shooting across fields that they have no business being on, they're sighting in scopes, and that's the current residents. Every weekend it's gonna be a battle with the people there. The land was to be preserved for agriculture, not for hotel management. It's not a Holiday Inn Express back there. That's what it's turned into. It's going to continue to be a problem. You know, we have several driveways that go down this road, and we have several hundred acres that butt up to this property. People will be turning into our property with the alibi, oh, we were just looking for the Airbnb. Oh, what's back here? Oh, you guys have this. Oh, I didn't know, you know, the barn doors are open. We thought we'd come in here and take pictures. We're out in the country. That's the type of thing you're going to get from people from the city. There's just, it's not meant for that. It's agriculture purpose. If they want to go out there for a drive and drive down the road, fine. But to come out here and now they're going to be staying, it's going to present a whole nother, lot more problems. Another part of this thing is I don't like his intentions. They're very vague. I think there should be a business plan written. Anytime there's a business that you need to have a business plan. Things are too vague. He seems like he has other intentions, and whether they're good or bad, I hope they're great. You know, I never got a doorbell ring up at my door to let me know what his intentions were. If I was gonna do some type of fantasy property like he wants to do, I would probably knock on his door as a respectable person, neighbor, and tell him what my intentions are before we got to all this. So that's why, as a farmer of past generations, my family's been on the farm for 200 years. We're not going anywhere. Doesn't matter if he's there, the next guy, we'll still be there. It's just like kind of like Yellowstone. And you got a lot of property, a lot of other people want it too. So you just got to defend it. I hope he's respectable. I hope he has a great time back there. I hope everything's great. But we're going to have situations where the person from Chicago drives down and gets stuck in the ditch. They're out in the front yard. You can't predict what's going to happen. It's going to be awesome because we'll be right back here explaining all these situations that have happened. You're going to not believe it. It's happened in the past. And we know the people that live there now we've had problems with. So these are some of my concerns, and these are the things I think about when I'm sleeping at night. So the other thing is, too, as you guys sit in your chairs, think about where you live, and if the house comes up for sale next to you, it being an Airbnb. Think about what that could turn into. Who's staying there? Are they convicted felons? Are they sex offenders? You don't know who's staying there. So think about that. And that's about all I got. I ran out of gas. Thank you.
Thank you. Next.
Hello, my name is Carrie Dill. I live at 16905 North Staub Road. I am the next door neighbor to this. I have 3 children. You can stand on our property lines and see inside my house. My children play out there, again, but up to the property. I am concerned, one, for safety. Again, stating we don't know if sex offenders are staying there. There's no background checks. They legally do not have to come to my house and tell me they're a sex offender like people do who live there. If they were to own that house, they would have to come and tell me this. They don't have to do that. Again, we've had problems with trespassers. I worry about, say, their driveway is what, about half a mile long? People are gonna be pulling in and out of my driveway thinking that this is the place they need to go. I don't want that. My kids, again, play in this yard freely without the worry of people coming in and out and having strangers wander through our yard and going back and forth and whatnot. Big, huge concern for me. I want my kids to be able to have fun. I want to be able to not worry about these things. There's also plenty of times my husband's a firefighter. He works overnight. So I am home alone by myself with my 3 children, often. Again, safety. I don't feel safe knowing that they're strangers, that I have no idea who they are, what their background are. Just, they could wander at any time of the night, do whatever they want, come into my house. Again, they could take pictures right from the property line. I don't like this. It's not something needed in a rural area where there are 5 houses on a road, where we've never had to worry about things like this with people coming in and out, the increase of traffic. It may not seem like a lot to people who live in the city, but out here for us, it's a lot. One thing I said the last time, it is pertinent to the situation because I've had issues with the bus coming to pick up my kids in the front of my house. I used to ride the bus. I was born and lived in this house, born and raised. The bus won't pick them up. They come up with every excuse under the book, and since we just finally got it seal coated, it's my big push to get them finally back to picking up our kids on this road. This is just another excuse with the increase of traffic to not come and pick up my kids. Another issue. It's caused a hardship for us because I've had to switch jobs just so I could pick up my kids from the bus stop a mile away. Another thing we've mentioned before, there are places like this. I don't know if you've heard of Giant Goose Ranch, over 800 acres. You can take ATVs on the trails. You can go hunt fishing with 52 ponds. There are kids-only ponds. There's a beach. You can take your boats out on there. They have cabins that rent up to 8 people. They don't have to worry about the water usage like you do where we live. We have an aquifer, 8 people. That's a lot of water being used, not including what they use outside. We have to rely and live on this water with the farmers around us too. And if that becomes a problem, it's going to be a huge hardship and it's going to be devastating. As of now, that's all I could think of. If there's any questions for me, please. Thank you.
Anybody else like to speak?
Good afternoon. Mark Walton, and I represent Doug Huff. I'm an attorney at Miller Hall and Triggs, 416 Main Street here in Peoria, right across the street. I appreciate all the neighbors' concerns. Anytime there's a change, people speculate. You heard a lot of speculation about things that are going to happen. That's the purpose of the restrictions that were addressed. But I want to address a fundamental point that I addressed to the ZBA. Every argument that you heard so far against granting this special use permit is an argument against allowing short-term rentals in the A2 district. They have nothing to do with this property and everything to do with short-term rentals in the agriculture districts. You could take every argument that was made and apply it to property on the opposite side of the county. But that's not why the Land Use Committee is meeting tonight. You're not meeting to consider whether you should allow, as a general matter, short-term rentals in the A2 district. You're here to consider whether this particular property is appropriate for a special use because the ordinance already, the county board already decided that short-term rentals are in fact appropriate in the A2 zoning district. So that's just a fundamental point, and I hope the Land Use Committee does not lose sight of that. When it comes to the need, it's easy to say, well, you could go to Wildlife Prairie or you could go to the Giant Goose Ranch. That may be true. There are other alternatives for short-term rental out in agricultural property. What makes this property unique is it's a single-family home that can be rented by a family that gives you all of those amenities in a secluded, so you're not on top of, a bunch of other cabins and in a secluded environment. And the restrictions that the zoning board recommended, that the county land use department recommended, address all of the concerns that are legitimate that relate to this specific property. So I've repeated a little bit of what I presented to the zoning board, and I just wanted to make those points. Thank you.
Thank you. Anybody else like to speak? Anybody else like to speak? All righty. Any questions from my colleagues here? Matt?
I guess this is more for Andrew. So like, do we have any restrictions on like outfitters or people hunting and fishing in the county? Do we have any even jurisdiction over that stuff?
The Department of Planning and Zoning does not have any restrictions of that sort. That's not to say that the Land Use Committee or the County Board could not impose those restrictions on this property. that's out of the purview of planning and zoning.
But all we're talking about today is the 5-acre parcel, correct?
75-acre parcel, yes.
But the 5-acre usage of it then?
There's nothing specific about 5 acres.
So the people can use the whole acreage,
Yes, sir.
but there is no clear cut distinguishing from, say, outfitter type use as opposed to,
So the county has a specific use for a sportsman's club. That's not what's being requested here today. They're requesting for an overnight accommodation. The overnight accommodation includes the use of the property, and it's the recommendation of the Zoning Board of Appeals that there's a restriction that hunting and or ATVs, I shouldn't say or, hunting and ATVs are not allowed by the renters or the users of those overnight accommodations.
and that's, they have agreed to that. That's what they wanted the use of the property to be, though.
It was not defined within their initial application. It was part of the testimony at the Zoning Board of Appeals by Mr. Huff that he was, I believe he was acceptable to those conditions.
That's what I mean. I guess he was acceptable to those.
He said it was not his intention, were the words used, it was not his intention for the folks coming to the property to be able to hunt or utilize ATVs. There was not any type of ATV vehicle provided. There's not, I mean, he was very specific in his testimony as to what amenities he personally was offering, and that it was not part of his plans to allow for hunting, to allow for ATVs. So when that restriction came about, I believe it came up during the deliberation phase of the Zoning Board of Appeals meeting.
All right.
So there wasn't necessarily comments by Mr. Huff. I suppose that today Mr. Walton perhaps addressed some of that in his brief comments. But at this point, the recommendation of the Zoning Board of Appeals is that there is no hunting or firearm usage by overnight accommodation renters, tenants. It does allow for Mr. Huff and his bona fide guests to continue to use those properties or this property in those regards.
Okay. Thank you.
Questions from, any more questions for Andrew? Andrew, can you explain to us and the audience what happens if we, let's say we were to vote this down, what are the reasons why or how we could vote this down? What are the reasons that we have to have or prove? So everybody understands where we're coming from, such as, you know, they met the restriction or all the requirements.
Right, so the ordinance has clearly defined standards for approval, oftentimes referred to as the findings of fact. So when the Zoning Board of Appeals makes a recommendation, they are looking at those findings of fact and determining how those are being met or those are not being met. Their recommendation was for approval. So should the Land Use Committee determine that they'd like to recommend denial, they would have to have findings of fact that support that denial. Does that address the specific question, Mr. Rosemont?
Correct. So just to make sure that my colleagues and the audience realizes that as long as we have the finding of facts that it meets the approval, if we don't vote for it, then the county can be in litigation. Am I correct? I guess I should look at Jenny on that one.
You would have to take the findings of fact and find on each factor of approval. You would have to find differently. You'd have to say that this fact that was found by the ZBA actually doesn't support approval under this factor. And Andrew, I apologize, I don't know the factors off the top of my head. You maybe do or know where to point in the code, but there are 7 factors that the ZBA they approved saying that the facts support the necessary, I think it's 7 factors, you all would have to say these facts that were found do not support these 7 factors that are in your code. And I think Andrew's grabbing the factors. So that's what you all would have to do. Otherwise, you would be overturned, could be, if it was appealed, you would be overturned on appeal, and you would be sent back to say that, you need to find consistently with the factors.
Right. So page 27 of your Land Use Committee packet is the minutes of the deliberation of the Peoria County Zoning Board of Appeals, and it does list those findings of fact for special uses as identified in section 20-3.5.4 of the Unified Development Ordinance. There are 5 standards for approval for a special use.
Are we able to call the question? I think we're ready to vote.
All in favor, say aye. Aye.
Aye.
Okay, that's 4 ayes, oppose. And we've got Terry abstaining, correct? Okay, so we have 4 ayes, no nays, correct? Matt? 5 ayes, okay. 5 ayes and 1 abstain, so it passed unanimously, correct? Okay. Okay. We are now at miscellaneous. Is there anything for miscellaneous from anyone? Okay, meeting's adjourned. Thank
Paul?
you, everybody. Whoop.
I have a miscellaneous.
Okay, sorry, Terry.
By way of an explanation to the dissenters, because I testified at the Zoning Board of Appeals, I cannot sit in judgment of this case. I can't vote on it because I supported your position during the ZBA hearing. Having said that, your presence here, and in order to separate this from Mr. Huff, your presence here points out the need for a comprehensive grip on a county-wide ordinance for bed and breakfast, Airbnb, short-term rental. We don't have that. We have a narrow set of guidelines. So each time this comes up, we have this list of restrictions that seem to be unique to every property. 3 years ago, we didn't have any of this kind of property. Now we have 9. 5 years from now, it's gaining popularity. We might have 50. So it's time for us to get a comprehensive Airbnb short-term rental ordinance. I think the understanding should be that this is not necessarily a bad thing. It's not necessarily a good thing either, as long as it takes into account the safety of the people who stay there, the peace of mind of the neighbors who live there, and respects the rights of people like Mr. Huff who want to invest in a business. A lot of you are in business. He has that same right. If he will take into account those other 2 very important things, the safety of his guests and the peace of mind of his neighbors, I think there's a way to say yes. But the county has to do our part too. So probably if this thing progresses the way it's moving, we'll get maybe 1 more restriction that would put every other year an inspection on top of this. If that happens, that's great. In the meantime, I'm going to trust that as we go forward, we're going to get a comprehensive ordinance that will apply to everyone. So I have no enemies in this debate. I think everybody has a place to make it work. So I wanted to explain to you why I was forced to abstain.
Thank you, Terry. Okay, any other announcements? Meeting adjourned. Thank you, everybody, for coming.